The defense offers you $990,000 to settle your case. You turn around and say, I demanded $1 million to settle this case, and I told you I would not take a dime less. What do you do in that instance? Do you settle the case, or do you hold out for another $10,000? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You brought a medical malpractice case against a careless doctor and careless hospital staff, and now, during the course of your lawsuit, it became obvious that your injuries are quite significant. It became obvious that you were limited from doing your daily activities on a regular basis, and you will likely have permanent injuries into the future. You will also likely need additional physical therapy, rehabilitation, occupational therapy to improve the condition that you are currently in. You have told your attorney during settlement discussions that you will under no circumstance settle this case for anything less than $1 million. Now, your attorney also advised you that even if the defense were to offer $1 million, this is how that $1 million gets divvied up. It gets distributed. First, out of that $1 million, all of the attorney's expenses gets repaid back to him and his law firm, because what they have done throughout the course of the last 2 or 3 years while your case was being prosecuted, they have paid for all of the expenses associated with your particular case. So they have loaned you basically all of the money necessary to go ahead and prosecute the case, with the hope and the expectation that if you are successful, either by settlement or by a verdict, that any money that they have paid out on your behalf would then be reimbursed and repaid to them and their law firm at the conclusion of your case. So using the hypothetical where you are now offered $1 million, out of that amount of money, now you have to repay the attorney's expenses. The remaining amount of money is then divided. How is that divided? Because now the attorney's fee is then calculated. And in New York, in a medical malpractice case, the attorney's fee is not 1/3. That only applies to personal injury cases. Medical malpractice cases are different, and it works on what's called the attorney's fee, is basically a sliding scale. So it only starts at 30% and then continues to drop as we get more and more money for you. So after the attorney's fee is calculated, the remaining amount of money is what you are technically entitled to receive. But I have to tell you one other thing, and not many people talk about this. If you are a recipient of Medicare or Medicaid or a specific type of insurance plan that we are obligated to repay, that's known as a lien, whether it's Medicare, Medicaid, or a specific type of insurance plan that has paid out money on your behalf for your medical expenses. In those instances, we now have to negotiate on your behalf to try and reduce the amount of money that has to be repaid to those agencies. Once that occurs, now that agency, like Medicaid or Medicare, will then get repaid that negotiated amount of money, and what you are left with is what you actually walk away with. So knowing that information, you have told your attorney under no circumstance will you take a dime less than $1 million, because you know you're going to be walking away with a substantially lower amount than the $1 million. So knowing that, you say, I would rather go to trial than go ahead and take a dime less than $1 million. So now your attorney has gone ahead and began settlement negotiations. This is now after 2 or 3 years of hard-fought litigation. And now the defense is actually willing to negotiate. They recognize they have problems. They recognize that their doctor did, in fact, violate the basic standards of medical care, causing you harm and injury. But they dispute the extent of your injuries. Your attorney might demand $5 million, knowing full well that he will never get an offer close to $5 million. On the other hand, he might offer something in the range of $3 million or $2.5 million to settle this case. The defense turns around and says, you know what? We'll offer you $250,000. We'll offer you $500,000. We'll offer $750,000. They will most likely lowball the attorney with whatever demand he makes. And now the goal is to reach a point where both sides are willing to accept what would be a compromise. So now your attorney knows that you will not accept anything less than $1 million. The conversations between the attorneys are critically important, and it's also important to know whether or not they have negotiated cases before. If they have, then there is a much greater likelihood that there is a level of trust between the two lawyers, between the plaintiff's attorney, your attorney, and the defense lawyer. And having a level of trust is very important for settlement discussions. If there is no prior negotiation history between these two attorneys, now there's a level of mistrust. Your attorney may say, listen, my bottom line in this case is $1.5 million. If you can come back to me with $1 million, I'd have a discussion with my client, but I'm telling you right now, $1.5 million is my number. The defense attorney goes back, speaks to their principals, and now comes back and says, you know what? We can't approach $1.5 million. The best we could do is $900,000 or something similar. So now, why is that important? Because your attorney has revealed to the defense lawyer, in a good faith effort to try and settle this case, what the number would be to settle the case, $1.5 million. And now he said, listen, if you come up to $1 million, then we'd be in a more favorable negotiating position, knowing your attorney knows full well that you need at least $1 million to settle, and anything above that would be beneficial for you. So now the defense comes back and says, you know what? There's no way we're going to offer you the 1.5. We're going to continue to lowball you. They don't say that. And now we're going to offer you just a little bit less. So what if, during the course of settlement discussions, your attorney says to the defense lawyer, listen, we can make this all go away right now. I need $1 million and nothing less to settle this case. And now, assuming they have a good faith ongoing discussion between the two attorneys, and assuming that there is a level of trust here and good faith, now the defense comes back and says, you know what? We think this case should be settled. We agree that this case has a substantial value, and we're not in disagreement with you about the $1 million. However, there are a number of other factors that are preventing our clients and our insured and our carrier from actually offering you the $1 million. They don't think we should be offering $1 million. So as an alternative, we are going to offer you $990,000. Please take that offer back to your client and let us know what he or she would like to do. So what do you do in that instance? Your attorney now calls you up and says, listen, I know you wanted $1 million, and the defense recognizes that the case should be settled, and they recognize the significance of your injury, but there are other things going on behind the scenes here that we are not privy to, and the only offer that they are willing to make is $990,000. The defense lawyer has told me, very simply and very plainly, they will not offer another dime. They are literally drawing a line in the sand, literally here at the beach, and now they have told me they will not offer another dime. So it's either take it or leave it. And if you leave it, there's a good chance that they will revoke their offer and take it off the table, and now they will force us to go to trial. What do you do in that instance? Okay, I'll tell you what you do. You have to have a long conversation with your attorney, and after you get over your outrage about the defense refusing to pay you that last $10,000 as a basically stick it in your back kind of maneuver, they may feel, listen, you know that you are going to take this offer, or at least the defense believes that you will take this $990,000. The defense attorney will look like a hero because he saved the insurance company that additional $10,000. And they also believe that your attorney is going to recommend taking that amount because they are weighing the risk of you rejecting it and going to trial. And they often will recognize and will often believe that an injured patient would much prefer to accept a substantial settlement offer rather than throw it all away and take the risk that a jury will, number one, agree with the claims that are being made, number two, agree that the doctor's carelessness was a cause of your injury, and number three, agree with the value of your injuries and give you at least as much, if not much more. They understand what it means to offer $1 million, but for whatever reason, they're just not willing to chip in that extra $10,000. And that could be a simple petty issue that you have somebody who's controlling the money and simply says, listen, as a matter of principle, we're not going to offer the full amount that's being demanded. In that instance, we'll give you $990,000. Take it or leave it. Does that happen often? I wouldn't say often, but it does happen from time to time. And now you, the injured patient, have to make an educated, calculated decision about what to do. So, is it easy to say, sure, go ahead and take that money? Absolutely. Is it just as easy to say, no, I'm not taking it because they didn't offer me exactly what I demanded and my injuries are worth it? Sure, that's easy too. So the alternative of rejecting this offer is that, number one, they could actually revoke and take that offer off the table. Now, that does not happen very often. And the only time I've seen that happen is when there's a substantial level of mistrust between the attorneys. And there's been bickering during settlement negotiations about what was said or what wasn't said, and now people have gone back on their promises and they've gone back on what they wanted to do. So that does not happen very often. So now, what is the other alternative? The other alternative is that now you are forced to go to trial. Now, going to trial is filled with uncertainties. There are no guarantees, and no attorney in the world, no matter how great, no matter what type of experience and past results they have achieved, could ever guarantee a particular result. The biggest hurdles you are going to have by going to trial is to show to a jury that you are slightly more likely right than wrong, that what you are claiming is true, that number one, your doctor was careless, number two, his carelessness was a cause of your injury, and number three, that your injuries are significant and or permanent. All three of those things have to be overcome, and a jury has to agree with you based upon what your experts have to say. Assuming a jury agrees with each one of those things, then they have to get to the question of how much money to give you as a form of compensation for all the harms and losses and damages you incurred. What could happen is that you could go to trial, you could win all of those three elements, that the doctor was careless and he caused you significant harm and injury, but the jury ultimately comes back with less money than what you are being offered currently. In that instance, you have a substantial problem. And now you're going to be stuck with either having to accept what the jury has decided or try and appeal it, claiming that the jury was totally wrong and totally misunderstood what the testimony was about your injuries. So that is an uphill battle that, if you are confident, even if you are confident, does not guarantee that you will overcome and obtain more money than what is currently being offered. So there's a lot that goes into deciding whether or not to accept or to reject such a settlement offer. And the bottom line is, and this is very important before I finish up today's video, the bottom line is that it is you, the injured patient, who ultimately has to make the decision about whether to accept or to reject such a settlement offer, after having a very detailed conversation with your attorney about the risks, the benefits, and the alternatives associated with each of those decisions. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you were thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.